immigrationquestion.com, your go-to resource for U.S. immigration insights. We provide clear immigration news and information. Our platform provides a network of licensed attorneys who can answer your questions and guide you through the process. From visas to green cards, asylums to citizenships, immigrationquestion.com helps you to network with immigration attorneys so that you can move forward with confidence. Sign up today or download the app. Free registration, limited time offer. Stay tuned. We go live in 30 seconds.
Hello, everyone, and welcome to today's live webinar brought to you by immigrationquestion.com, a networking platform and meeting ground where individuals, employers, and licensed immigration attorneys engage, learn, and exchange insights on U.S. immigration developments. My name is Max Castro, and I'll be your host for today's timely discussion, Immigration Strategies That Work, Balancing Compliance and Workforce Needs. In today's global economy, immigration law does more than determine who can enter or stay in the United States. It shapes how companies build and retain their workforce. Employers must manage strict compliance obligations while striving to attract international talent, and immigrants must navigate complex visa processes to maintain lawful employment. Striking that balance is challenging but achievable with the correct information and preparation. Today, we are joined by attorney Alka Bahal. Attorney Bahal is a nationally recognized immigration attorney specializing in corporate and business immigration, visa sponsorship, and I-9 compliance. She provides strategic, practical solutions that keep our organizations compliant while empowering professionals to thrive in the United States. You're welcome, Attorney Bahal. Thank you so much for joining us today.
Thank you for having me. It's quite my pleasure.
Of course. But before we begin, a quick but essential reminder, immigrationquestion.com is not a law firm and does not provide legal advice, guidance, or representation. This platform serves as a public meeting ground where individuals and organizations can learn about immigration topics, ask their immigration questions for free, and engage with licensed attorneys who participate independently. To our viewers, it's about time for us to have a very good and very interesting conversation. Grab your writing pads and pens and let's dive right in. Attorney Bahal, could you walk us through how immigration compliance has evolved in the corporate landscape and why it has become such a central issue for U.S. employers today?
Absolutely. It'd be my pleasure. So one of the reasons immigration has become so central to workforce management and topics in the public eye these days is enforcement has increased tremendously, particularly in the last 5 years, but on a steady increase, I'd say for the last 20 years. In the 80s, if you did some basic things, you would get some visas, you could get your I-9s, it was all good. Now, almost every visa process is some sort of an uphill battle. It requires a more in-depth, preparation, planning, and strategy. And all of it is because enforcement is at an all-time high. Adjudications at the various agencies are more difficult. They're strict. They're scrutinizing things very, very carefully, but also complicated by the fact that in those agencies, a lot of individuals are not as trained as we would like. And so there can be mistakes. They can overlook essential information, which just makes the mechanics of the process that much more difficult. So immigration compliance is really at the forefront of any sort of an immigration program, whether you're talking about onboarding, I-9s, or actual visa sponsorship of foreign nationals.
Thank you, Attorney. And many organizations struggle to balance business growth with regulatory obligations. What are some practical strategies companies can adopt to stay compliant while still meeting their workforce and talent acquisition needs?
Well, I'd say first and foremost, the most important thing is to have a qualified and knowledgeable attorney by your side, an immigration attorney that is really well versed in not only the mechanics of how to obtain a visa, who can qualify for the visa, and the basics, but also understands the overall strategy, planning, possible pitfalls, and definitely the gains that are to be had by being able to sponsor and employ foreign nationals. I think more now than ever, strategic planning is critical for any size business organization that has foreign national employees, whether they are here as students and we are, employing them without direct sponsorship, but may want to keep them in the long run, or we have maybe a big portion of our workforce who are foreign nationals. And there are so many moving parts that now affect immigration, including political trends, enforcement priorities, as well as these adjudication trends of particular agencies, that having an immigration attorney who's really in deep with these issues and sees them on a daily basis is important to help any organization with their strategy, even if they have a decent sized program, because, we can see things from more angles. We get a lot more variety of information. And so attorneys can assist businesses in their strategic planning, which is really critical these days, not only in terms of being successful and keeping your employees or getting new employees, but also managing those costs. Obviously, as enforcement increases and it becomes more difficult to get visas, costs increase. In addition to USCIS and many agencies raising their own fees that we're paying directly to these agencies to process our applications, as the process becomes more complicated and requires more time, more skill, and more knowledge, the cost to process it is also increasing. And so it's really important to have that correct strategy in place so that you're not spinning your wheels, you're not spending money that's not getting you somewhere.
Thank you so much, Attorney Bahal. And the Form I-9 process continues to be a primary concern for HR teams and employers. What should businesses understand about preparing for potential I-9 audits or government inspections in this current enforcement climate?
I think that we are certainly in an all-time high in terms of immigration enforcement. So again, any employer of any size, when you have employees, you have I-9s, you should be looking at those I-9s and your processes on how you complete those I-9s, because both of those elements will be looked at in an I-9 inspection. I think we are sort of as things have increased and ramped up dramatically in the years, I still think that there's more to go. I don't think we are at the pinnacle of enforcement. I think it's still going to continue to be ramped up. So it's more important than ever for employers to take a look at their I-9s, the actual forms, the actual process, whether you use software providers or whether you do it manually, now with qualified immigration counsel at your side, for a couple of reasons. One, if we are going to make any corrections or correct course corrections in how we're doing our I-9s, those are only going to be as good as our ability to get them done before ICE shows up. If ICE shows up to inspect our records, it's too late. They are what they are, and we're not going to have an opportunity to do better. We'll have to face potential fines, if we have serious issues, potential future, restrictions or obligations in terms of additional inspections. We'd really rather not be there. So the only way internal private audits, looking at your own records and improving them, is going to help an employer is if they can be done before immigration shows up. One of the reasons I recommend you do this with qualified immigration counsel is, again, we have this experience behind us, right? So in my experience personally, I'm not just looking at it from the perspective of helping a client look at their own I-9s, their own process and their procedure. I also have the experience of defending these clients before immigration and customs enforcement. So I have this sort of live feedback on what do they want to see? Where are their current priorities? What do they see as an issue that maybe I didn't think was an issue, or the rules don't necessarily lay out as a potential issue? Immigration is a strange area of law where not everything is like dictated by regulation. We have policies, we have trends, we have all sorts of other documented issues that affect how the outcome of our processes. So, it is something that I recommend any employer, and the I-9 applies to all employers in the United States, any number of employees. And no matter how many employees you have, it is something that it merits taking some time and some effort to clean up. No matter, what that involves, hiring a lawyer and cleaning up your records is going to be less costly and less painful than doing it after ICE shows up.
Thank you very much, attorney. That is very enlightening. And from a foreign professional's perspective, how can immigrants position themselves with corporate frameworks to maintain lawful status and enhance their long-term career and sponsorship opportunities?
The number one thing I would say is to be communicative with your employer and your counsel. Usually the employer is the counsel for the employer and helps with the foreign nationals visa processing. To the extent you are clear and honest about where you are, what's going on, what's being done, the better off you will be. I would say, there's absolutely no reason why you shouldn't voice where you want to be, where you would like to be, what you would like to see happen. But be aware that, again, as qualified immigration attorneys and professionals, we can tell you sort of the guidelines of how we can get you from point A to point B. And at the end of the day, business immigration is generally driven by the employer. So the employer has its own set of obligations in terms of what can it advertise, what kind of requirements can it have for a position, and what is it putting forward to immigration in terms of who it is and who its employees are. And that all has to make sense in the context of all the employer's applications. So each employee's application is sort of a cog in the wheel, and we have to make sure that the whole picture makes sense. But to the extent we're able to achieve any individual's, goals or objectives, we can do that. But again, it's all about being clear and communicative. The best way any foreign national is going to make sure they are fully in compliant with their own visa processes is if they are communicating to their employer and to their lawyer where they are, what they're doing, if there have been changes. One of the biggest issues we face post-COVID is where is the employee located for employment purposes. In the visa context, this can be critically important because in a work from home scenario where you have an H-1B visa, your home is your work site, and that is what is disclosed in your visa petition. If you decide to change your work site, in other words, changing your home location, and you haven't notified anyone at your employer because you're working from home and maybe you don't have any other obligations to notify them, it can directly impact the validity of your visa petition and your status and your authorization to work in the U.S., which, as we all know, if we violate those things, there are severe consequences to our foreign national employees as well as to our employer. So my number one piece of advice is being clear and communicative.
Noted, Attorney Bahal. And with the changing visa regulations and ongoing policy updates, how can businesses build immigration programs that are both flexible and resilient, especially when managing H-1B, L-1, or other employment-based visas?
It is definitely becoming more increasingly challenging. As the complexity increases, so does the hurdles that we have to overcome in order to keep our workforce employed, authorized, and continuously in compliance. Again, my number one piece of advice is to have qualified immigration attorney at your side who's assisting you, and you are looking forward as much as possible. To the extent we can see, are we going to potentially have 5 H-1Bs we need to file for under the cap next year? Maybe we will file for all of them, maybe we won't, but let's start having those discussions now because things are evolving so quickly and there are so many moving parts with many of these visa processes. To the extent we can get ahead of them and start thinking about how we will address something for a particular employee, for a particular group of employees, or for future planning, the better off we can be. And that way, the more strategy any employer can apply, the more chances of success they will have in having a successful program.
Very well said, attorney. Thank you so much. And to everyone joining us live on Facebook, YouTube, LinkedIn, and other platforms, thank you for being part of this essential conversation. Whether you're an H-1B professional navigating uncertainty or an employer seeking clarity, this discussion is about awareness, preparation, and informed decision-making. Suppose this is your first time joining us? Welcome. Immigration Question is a networking platform where immigrants, families, and employers can ask immigration-related questions for free and engage directly with licensed immigration attorneys. You can participate in any language, and many users may also qualify for a free confidential consultation. We're also proud to share that Immigration Question is now BBB accredited, a recognition for our ongoing commitment to transparency, accountability, and service to the immigrant and business communities across the United States. Attorney Bahal, as an immigration attorney yourself with extensive experience specializing in corporate and business immigration, visa sponsorship, and I-9 compliance, what are your thoughts on how a platform like immigrationquestion.com is helping immigrants and attorneys network effectively?
I think it's a great platform to connect those foreign nationals and employers who are looking for advice or counseling in a particular area and then really don't know how to reach out to or where to locate a qualified immigration attorney.
Thank you so much, Attorney Bahal. And just before we move on into our Q&A session, what emerging trends or upcoming policy shifts should employers and skilled immigrants should be aware of? And how can they prepare proactively to stay compliant and competitive in a global market?
Well, there's a very long list. There is a lot going on with immigration these days, especially in the H-1B arena. It is all over the news, so it's not hard to to know a little bit at least about what's going on. The number one piece of advice I give to anyone who is kind of looking to the media to stay abreast of immigration or immigration changes is to know your source. So there is a lot of misinformation online, not just about immigration, about other stuff, but with respect to immigration specifically. Look to known, reputable news sources or directly immigration itself, uscis.gov, Department of State, travel.state.gov, to get your information. Now, of course, under the current administration, we get our information in other interesting ways from these agencies, including Facebook and Instagram and X. So I guess we can look out there, but look for information that's coming directly from an agency, from a reputable news source, or from a trustworthy immigration firm or attorney. Other information, one of the kind of the things with immigrant communities are we talk, we share, we look, we share information. But it can be dangerous because, as you know, if you ever played the game of telephone when you were a kid, as stories get passed on and get repeated, they lose their truth. They become embellished or they're heard differently. And so they're retold differently. And the messaging that originated with that story can change over time. So I'm very cautious about sort of this repetition and sort of the friend network in terms of what was done, how did it get done, how quickly was it approved, etc. So be educated, look for this information, but again, look to your reliable news sources to get that information.
Valuable insights, Attorney. Thank you so much. And if you're just joining us, we've been having an engaging conversation with Attorney Alka Bahal on the topic immigration strategies that work, balancing compliance and workforce needs. We're now moving into our live Q&A session. This is your opportunity to ask questions directly to a licensed immigration attorney. Drop your questions in the chat or call us live at 516-703-3483. That's 516-703-3483, and we'll take on as many as possible during this session. All right, so we have our first question already. We have one from Damien. He's asking, have interview for adjustment of status through marriage should take a photo album with original photos, even though I'm taking new updated 4 to 5 picture PDF style or on a letter size page to the interview.
So this isn't entirely business or corporate immigration, but I can give you some advice. Really, it's up to you. So when you are in your marriage adjustment of status, they are looking to see that it's a bona fide marriage. What evidence do you have to demonstrate that you are truly married, that you hold yourselves out to the public as a married couple, that you're living together and doing all the normal things a married couple does? Photographs can be a key element to that proof, But determining whether you should take original photos, a printed PDF, or the combination really is a question of what is the overall set of proof that you have. If that's all you have, then I'd recommend you want to take a lot of originals with you. But it really should be one of a number of different types of documents that you're carrying with you. The other piece of advice I'd give is anything that you take with you to immigration in original, take with a copy, because otherwise, if immigration wants to keep a copy of it, they're going to keep your original, which may or may not come back to you at some point in the future.
Thank you so much, Attorney. Shall we wait for the next question? We have one from Axelilla. Does receiving a severance package impact my visa status or ability to apply for a new one?
So receiving a severance package alone does not impact your ability to obtain a new employer or change your visa to a new one. But to keep in mind that the severance package does not change your last date of employment. Your last date of employment is what is going to trigger the end of your compliance with that actual visa, whatever it may be, H-1B, L-1, and it could create the clock to start on any sort of a grace period, the time that you are limited within to apply for a new visa. So as long as you understand severance package is one thing, the termination is a separate issue. Absolutely, the severance package is not a problem.
Right, we have another one from Ashutosh. What are my options for maintaining legal status after the grace period expires?
So this could be in the context of several different things. I'm looking either to an H-1B where we have perhaps left our H-1B employer. We have a 60-day grace period. Could be a student who's completed their employment authorization period, completed their course of education, has a 30-day grace period. So these are various grace periods that come in the immigration world. In order to stay here beyond your grace period, you need another visa. You either need to depart the United States at the time that grace period expires, or you need to have filed to change to a different status. The purpose of the grace period is, sort of either a wind down and wrap up, as in the case of a J or an F1 status, or the time to either apply for a different employer to extend and amend your visa or apply for a different visa. That's the real purpose of the grace period.
Thank you, Attorney. We have one from Sarah. Can the company revoke my approved I-140 or is it portable?
So these are really two separate questions. An employer is allowed, it can always revoke the I-140 petition. It is an employer's petition, so it can be revoked. Whether the petition is portable to an individual and for what purpose that portability supports is different depending on how and why you want to port it. So if you are looking at what we would call adjustment portability, where you have an approved I-140 with employer A, you have filed for your adjustment of status, and you had that pending for at least 180 days, you left employer A, you joined employer B, and employer A decides after 200 days to revoke the I-140. Can be done, and the employer is allowed to do it, but it does not affect your ability to continue to adjust status on that I-140. It remains available to you for portability purposes. So that's a benefit. If you are in a different scenario, you have an I-140 approved on your behalf from employer A, but you are unable to file for adjustment of status because of your priority date being in a backlog, and you're having a new employer file a new labor certification and hopefully a new I-140 for you. If employer A revokes that I-140 before you can secure a new I-140 approval with the new employer, it could be problematic. You're going to need a lawyer who's going to look more in depth into that issue and the timing to see, are you going to be able to port that I-140 for the priority date purpose only, because that's all you'll be able to get from it. If there are other portability situations, which I'm sure there are out there, it's going to get a little too technical for us to dive into today. So we're going to have to move that into an individual question, looking for some case-specific information.
Hopefully that helps, Sarah. We have one from Zindika. My employer said I must stop job till I renew visa. Is that necessary or they want to fire me?
Unfortunately, it's impossible for me to tell. I have absolutely no idea what your visa status is or what is being extended. Could there be a scenario where you are not authorized to work until something's approved? Absolutely. That certainly does happen. My recommendation in this context is if you do not understand what is happening with your visa, then you need to be asking some other questions and understanding what is your visa, what are you allowed to do, and what are you not allowed to do. In my personal opinion, if they wanted to fire you, they would simply fire you.
Thank you, attorney. We have another one from Devi. If HR makes a mistake in my document, can it affect my legal status or only the company?
It depends on what document you are talking about and what the mistake is. Unfortunately, I can't opine on that without understanding more facts.
Thank you, attorney. We have one from Mara. My employer said I can start job while OPT pending. So is that legal?
Again, it depends. If we are talking about a student who has just graduated and you're applying for your first OPT, it depends. Is it designated in your Form I-20, and do you have an updated I-20 that says you are work authorized and for that employer? If that is the case, then yes, you're probably authorized to begin working. If, on the other hand, you don't have an updated I-20, you're waiting for your OPT EAD to be issued, which generally shouldn't take that long these days, and your employer is looking to start you before then, it could be questionable. But really what the test should be there is, can you complete the Form I-9 upon your initiation of employment? Now, the Form I-9 is that onboarding document we talked about a little bit generally earlier. And in that process, you have to show your employer that you are legally authorized to work for them. So when you go through that process, if the documents that you are able to provide to them show that you're authorized to work, you're good to go. If they're not showing that you're authorized to work, then your employer should not start you until you have those documents.
Right. We have another one from Hassan. Can my company move me to a different office in another state without new filing?
All depends on the visa type. In those cases where there is a location tied to the visa, such as an H-1B visa, it depends on what was disclosed in that visa application. If it already covers multiple work sites, you can be moved around to the already disclosed work sites without anything being filed again. If it is instead an H-1B petition for a specific work site at location A and you're moved to location B, then a filing needs to be done at some point, and at some point hopefully concurrent with the transfer, for location B in order for your H-1B visa to remain valid, both for you and for your employer.
Thank you, attorney. We have one from Fida. Please, if I change role inside my company, do they need to file again or just update the record?
Again, that all depends on what the change in the role is, what petitions you have pending or approved on your behalf, and where we're looking to be in the future. So if it is a permanent residency application that has been filed and approved, and you've moved from something in accounting to something in IT, and this is a really material significant change, yes, that can certainly affect any petitions that are either filed or addressing your visa status, or that you look to rely on in the future for permanent residency. If it is a change such as you are a software engineer and you've moved to a senior software engineering position, it's unlikely that that change is significant enough to warrant a new filing, independent of a need for a normal extension or amendment. Like, that should just be captured in the next due course.
Thank you so much, attorney. All right. AP is asking, do you think the lawsuit will get an injunction of the H-1B 100K fee?
It's a good question. Your guess is as good as mine.
Thanks so much, AP. Right. We have one from Joyce. Many of us worry about layoffs and compliance checks. So what is the best strategy to stay safe and legal?
So I'm not sure what compliance checks are, but layoffs certainly are a distinct possibility. And all I can say is it's important to be in communication with your employer so that we know what is going on. And to the extent your employer can give you a heads up of anything that is approaching on the horizon, the better off you are so that you can plan accordingly. It may not be a bad idea that if you do have a distinct thought process that layoffs are going to affect your industry, to try and strategize a backup plan if you can. Like, will you move to a different visa? Do you have a spouse? Then you can move to a dependent visa, even if it's a stopgap until you can find something else. To think ahead again and strategize is really important these days. If you're not sure in your particular situation what's available to you, pay for a consultation with a qualified immigration attorney who can evaluate your whole situation and maybe help you strategize what options could be out there for you.
Thank you so much, Attorney Bahal, for walking us through all of the nuances. Clearly, a lot of people, we definitely need the support of an immigration attorney like yourself. Your discussion on compliance, workforce strategy, and visa planning has offered precise, practical knowledge for both employers and professionals navigating today's immigration system. And to all our viewers, thank you for joining us. We hope today's session helps you plan, stay compliant, and strengthen your path forward in the U.S. workforce. Remember, you can always visit immigrationquestion.com to ask your immigration questions for free and engage directly with licensed immigration attorneys. Many users may also qualify for free confidential consultation. If you'd like to revisit today's webinar or share it with your colleagues, you can do the full replay that will soon be available on Spotify. To search Borderless Talk by immigrationquestion.com. Join us again next week for another informative discussion on immigration policy, workforce mobility, and compliance trends shaping America's future. Once again, thank you, Attorney Bahal, and thank you to everyone watching. Until next time, stay informed, stay compliant, and stay connected. Appreciate you having here, Attorney.
Thank you for having me. It was my pleasure.
Thank you so much. You have a lovely rest of your day.
You too. Bye, everyone.
Thank you.